and certain multinational oil companies from that country. Kenya, for purposes of its laws, has never made this particular initiative. And therefore, my lord, it is why there is a divergence on that point, that whatever the value of the MOU, based on that MOU, the respondents cannot act as though Kenya has already complied with its laws. Kenya has not complied with its laws. It has never pushed for this by its own initiative. And therefore, based on that divergence, it is our submission that after the ruling of preliminary objections, the responsibility for Kenya and the respondents in this case was to ensure that Kenyan law is implemented. This implementation of Kenyan law is not taking place. And the petitioner are dissatisfied with that. That issues of divergence is the issues of the MOU. Initiated by society, by Somalia or whichever way, the ICJ said that was a valid treaty between Kenya and Somalia. My lord, under international law, and under the Kenyan Constitution, Article 2.6, where there is a valid treaty, the treaty must be implemented. And as we had cited, saying, the Kenya had agreed with Somalia that these issues will be done after the commission of CLCS is done with its job, and then we make the agreement. CLCS has yet to do its agreement. So that it is my submission that the only position that was available under the law, and in this case both Kenyan law and under international law, on the respondent, is to ensure that the MOU is implemented. It was not to take the choice to participate in proceedings that are on the face of it unlawful. The next issue is on the impact of Kenya's reservation, the divergence. My lord, it is important to say that the 1965 reservations, the impact of Kenya's reservation, that is the 1965 reservation, on the issues of the current dispute. My lord, the respondent seems to take the position that based on the ruling on preliminary objection by ICJ, our reservation does not truly matter. But my lord, it is my submission that reading the decisions of the ICJ on preliminary objection, if it said to the extent that it purported to say, Kenyan reservation had shortcomings, it is not excluded jurisdictions categorical enough, it is my submission, as long as Kenya meant, and it has already acted on it with Tanzania, as long as Kenya's intention was that this reservation would have a specific effect, it is my submission that, and the petitioner's case, that Kenya still has options under international law. And that option is that that declaration is amendable. That you can amend it in order to expressly exclude the jurisdiction. It is within the terms of reservation. And therefore, it is my submission that as long as there is a written document in plain English that the petitioners states excludes jurisdiction, there cannot be jurisdiction. Issue number 5 is the issue of should Kenya stop participating in the proceedings before the ICJ? The respondents appear to say, well, it's okay because the court requires us to continue participating. But many of the petitioners are saying, if you have problems with jurisdiction, and meekly, as the petitioners have argued in their 2 affidavits, and meekly you continue to participate in such proceedings, then you acquiesce into the jurisdictions of ICJ. So that when finally a judgment comes, a judgment that is against you, because of your acquiescence, the law requires that you must implement that judgment. And if you don't, the UN Security Council can take certain actions against you towards enforcement, including sanctions. Therefore, my lord, the petitioners are saying that the respondents, as long as you take issue with saying that you do not have jurisdiction, the only position that is available is not to offer acquiescence to that jurisdiction. It is to withdraw from further participation. And as a sovereign state. My lord, within the next 10-15 minutes that should be over. Because of the background that was necessary, they just permit me. I'm going now to the main issues of the application. So that, my lord, the particular issue, because if we are a sovereign state asserts its position. My lord, national law and international law, properly understood, are means by which sovereign states can protect their vital interests, including of their people. And what is at stake here are the rights of Kenya as a coastal state. What is this right? These rights, my lords, is a simple one in the understanding of the petitioners. Which is this? That Kenya has about a coastline whose length is 536 kilometers. Somalia has a coastline, the longest in Africa.
Kenya has a coastline?
Over, I believe it's 536 kilometers. Somalia's coastline, which is the longest in Africa, is 3,333. 4 3s. But the understanding of the petitioners is that as a questions of justice and equity for purposes of the delimitation of the ocean, the duty of the respondents as representatives of the Kenyan state, and by respondents, my lord, for purposes of international law, the Kenyan state is understood to mean its executive, its legislature, and its judiciary. For purposes of this case, we have seen what the respondents have done. I mean the Kenyan legislature and the executive, that is through the respondents. Now, what is, of course, is remaining, and which is the only forum that the petitioners as citizens of a country can go to, is the judiciary. Role of the judiciary is as part of the integral element of the Kenyan state. The duty of the Kenyan state, thus understood, is to ensure that as a matter of international justice, as far as delimitation of maritime territory is concerned, Kenyans must have a projection of its coastlines into the Indian Ocean equitable to 536 kilometers. That is the minimum. But what the scenario that now face Kenya? The scenario facing Kenya is that before UNCLOS came, it had agreed its southern maritime boundary with Tanzania on the parallel of latitude, basically saying that it is a straight line, and which are represented in the graphics from page 24 to page 28 of the affidavit of Kerero Wagoge. Well, the page 24, the small affidavit, to 28. There are several graphics to show the impact of
the boundary with Tanzania and the proposal by Somalia, and of course the Kenyan maritime claim. My Lord, as a result, now that the southern boundary is already settled, the northern boundary, to be settled under the principles of UNCLOS, the equidistant, would effectively mean that Kenya cannot project both into the economic EEZ, exclusive economic zone, and the outer limits of the continental shelf, a projection that is equivalent to its 536 coastline. It would have, at some stage, a very narrow entry into the Indian Ocean. The bulk of its fishing area outside the 200 nautical miles EEZ would effectively, 5% of it, would be taken by Somalia, and Somalia would share that boundary with Tanzania, so that the outer limits of Somalia will share boundary with Tanzania, so that effectively Kenyan ships and the Kenyan people will not be able to project into the high seas without passing into areas in which Somalia has effective control over. Well, the petitioner's case is that the respondents to act and to make decisions in a situation that will occasion this fundamental injustice on the Kenyan state and its people is completely unacceptable. And that this country, based on national law and that this court, based on national law and international law, can do something about it. What is this that this court can do? There are the reasons for the application. The applications, my Lord, is seeking in the order that pending the hearing of this petition, of course, we shall have to say a lot of most of these things that we have said when that day comes, that there should be an injunction to restrain the respondents from further participation in the proceedings before the ICJ. And of course, there should be an injunction to restrain the respondents from engaging, from further participation in the proceedings in the Somalia versus Kenyan case before the ICJ. That is prayer too. And that pending that, the respondent should also in prayer 3 should be restrained from taking any measures or decisions that may lead to the alteration of the Kenyan territory as envisaged by Article 5 of the Kenyan Constitution as at 27th of August 2010. What is that territory? That will probably be the first question. That territory, my Lord, is the territory concerning its land, the Kenyan land, the territorial sea, and the exclusive economic zone, on which by the 27th of August 2010, when the constitution was promulgated, Kenya was exercising effective sovereignty over, pursuant to the presidential proclamations of 1975 and 2005 that had been registered with the United Nations as required by law. Those are the territories in question. and that the same constitution requires, these territories cannot be altered without a referendum. It is the case of the petitioners that under sections 4 of the Maritime Zones Act, it is contemplated that if and when such an agreement is made, the issue can be placed to the referendum. And therefore, my Lord, it is my submission that the Kenyan territory in question, why it will be but the direct reasons, the more and the most important one.